Hey guys, Dark Angel here. Got another one for you. Actually, this is not another one. This is a recap. I've done this video once before, but not with this right here. So, expressio unos este exclusio otros. Remember when I kept telling you guys about the legal maximum? Okay, I just got on someone else's webpage and they were talking about not webpage, YouTube channel, and they were talking about the statutes and how US whatever 18 and all this, the definitions of the words motor vehicle and how you needed a license and all that. And I told him, I said, no, you're wrong. The statutes, it doesn't matter that the state has a different definition of statute. And then when you go into the statutes of the feds, they actually have like several different definitions of the statute for motor vehicle. And I told him, I said, what you need to look to is the law of the land, what the Supreme Court said. The Supreme Court has defined motor vehicle. So I'm going to leave that at that and show you why the right to travel is lawful. So if you read right here at the top where it says literal meaning, the explicit mention of one thing is the exclusion of another. Go down to explanation. The legal maxim simply means that if one of the two possibilities of an event is talked about expressly, then the second possibility is kicked out by default, since simultaneous occurrence of both possibilities of a single event is undesirable and not valid under the law. In order to make a particular outcome valid and admissible, the other aspect has to be completely knocked out. It can also be understood as when one or more things of a class are expressly mentioned, others of the same class are excluded. The legal maxim forms the basis of the statutory. Hang on one second. Hang on one second. The statutory, okay, provisions of law and states that inclusion of a specific category or class excludes the other completely, since inclusion of two contradictory statements is violative of the principle of natural justice. It is also a prominent characteristic of law that an implied exclusion argument lies whenever there is reason to believe that if the thing expressed wait a minute apply, damn it, my bad guys, my bad. That if the okay that if the legislation had meant to include, okay, now I want you guys to pay attention to this, and I'm sorry for the mess ups, okay. So I'm going to take you back over here to right there. It is also a prominent characteristic of law that an implied exclusion argument lies whenever there is reason to believe that if the legislator had meant to include a particular thing within the ambit of its legislation, it would have referred to that thing expressly. Because of this expectation, the legislature's failure to mention the thing becomes grounds for inferring that it was deliberately excluded. Although there is no express exclusion, the exclusion is implied. The doctrine is useful not only in determining the extents of contracts, but also plays an important role in the construction of statutes. It can be interpreted as where certain persons or things are specified in the law, contract, or will, an intention to exclude all others from its operation shall be inferred. In such a case, the reference to the assignment to a financial institution excludes assignment to any other entity. It is pertinent to note that the express inclusion of one may be an act, a statute, or a provision, leads to exclusion of the other. This is a well-established condition that express inclusion of one means implied exclusion of others. Illustration. Let us assume that initially A and B enter into a written contract over a certain matter. Then later on, B cannot depute C on his behalf to execute the contract. Therefore, it can be observed that entering an express contract between the two parties, A and B, excludes any possibility of a third party, C, stepping into the contract during its execution. Well. Likewise, if a specific act is barred by the law of land, expressly under any of its statutes, then its commission is impliedly illegal and punishable. For instance, smuggling is an illegal act and is expressly barred under the Indian Penal Code. Any act in furtherance of some act or any other act of this class is illegal and shall lead to harsh consequences. Another example is that the inclusion of an expressions like notwithstanding anything contained in this section in the provision bars the possibility of inclusion of any other condition. Case laws. Arnold Therm's case, Ledane Jr. applied the expressio unis principle of construction 224 of the Charter. Subsection 2 of a 24 provides that a court shall exclude evidence if its admission having regard to all the circumstances would bring the administration of justice into dispute in the decision appealed from. The majority court has the discretion to exclude evidence under SS1 of S24 if it considers it appropriate and just in the circumstances to do so. Ledane J., with whom 5 other members of the court concurred on the point, came to a contrary conclusion. Now, you want to sit there and try to dispute what I'm saying. Like I said, this is a uniform rule that is used by all courts, okay? So in the writing of the statutes, okay, if the legislation intended for the statute to apply to that of personal, private automobiles, it would have been included in the statute. When the United States Supreme Court ruled that a motor vehicle was a vehicle used for that of commercial purposes, and that a automobile connotes as a personal private pleasure vehicle, okay, no statutes ever included personal private automobile within its writing based on statutes handed down by the legislation. Okay? So, what does that mean? That means that personal private automobiles has been excluded from the statutes, regardless of what the state statutes wrote and what their definition of a motor vehicle is, regardless of what the feds wrote and their definitions of what a motor vehicle is. None of that matters. The bottom line is the Supreme Court defined what a motor vehicle is, and pursuant to that law, the law of the land, the what? Mandatory law, okay, that is the law that matters. Okay, so when you go to do your case, or you go to do an appeal, or whatever it is you're going to do, you know, they can sit there and say whatever they want, you know, but the bottom line is this law right here, this rule right here, is what makes traveling in your personal private automobile perfectly legit. Okay. And here's the thing too, you know, you can say, oh, well, you know, wow, you know, that's pretty cool. And it is very cool. It's very, very cool, because of the simple fact is you don't have to be a state national. You don't have to be a sovereign. You don't have to be a foreign national. You don't have to be any of that. This is American. This is America. This is the law. It's written right in the law. However, this right here gives the state national, such as myself, it gives the sovereign, it gives foreign nationals more power. This is a universal law, guys. Okay, this is used all the way around the world, and this law can be tracked all the way back to Roman times, all the way back to the Roman law. So, you know, if you really want to get into what legal maxim is, it's not just this expression right here. Okay, it has plenty of expressions. I actually have the entire book, but I just copied these out, so just so that you can see them. This is just some of the, okay, this is just some of them. Like the first one right there, ignorantia juris non excusat, right? This is what it says. This translates to ignorance of the law excuses no one. It emphasizes that individuals are expected to know and abide by the law, regardless of their awareness of lack or lack thereof. And as you can see, it's got plenty of them, you know. And the book, when you actually look at the book, it actually looks just like a dictionary, you know. So again, excuse me for the snorting and sniveling and all that. Like I said, you know, I'm under the weather. So I just wanted to hit you guys up with this little messed up video. Again, I apologize for the quality of the video. I apologize for that, but the information's out there. And if you're ever on Steve Leto's channel, okay, tell him that the Dark Angel said, dummy, because, you know, he claims that he's a lawyer from out of Michigan, and that, you know, he did a video on statutes. And when I asked him about this law that's been used since Roman times, and even this law is actually cited. If you guys remember, I did the City of Chicago versus Banker case, the case I told you about that the feds pulled off the shelves. Guess what? This law is actually in there that won the case about not needing a driver's license to drive your personal private automobile. That's what the case was about, is about. For any of those of you that don't know, that's what that case was about, this case right here. This case actually mentions, that's interesting. I didn't even think about that until just now. Check this out. So here's the case that I was just telling you about right here. City of Chicago versus Banker. Okay, this is that case. This case has been pulled out of every law libraries. You can't find it online. Why? No license for private automobiles. Huh. Okay, so we're going to flip through the page. I'm going to get straight to the point for you, and I'm going to show you this, what I'm just doing, this legal maxim. I'm going to show it to you. It's interesting because this case is a 1904 case. Okay, 1904, guys. So it goes to show you how long it's been around in the United States. Okay, so let me see here. Okay, so let's start right here. Okay, so the speed of an automobile may be regulated, and reasonable safety appliances such as gongs, brakes may be required. But to compel one whose use of his automobile for his private business and pleasure only to submit to an examination and to take out a license if the examining board see it fit to grant it, is imposing a burden upon one class of citizens in the use of the streets not imposed upon the others. We must therefore hold this ordinance so far as it obliges a palee to take out a license before he can use his own automobile to his own business, in his own business or for his own pleasure, is beyond the power of the city council and is therefore void. Now, let me go back and I'm going to actually show you where it says Bassett versus the People. The Supreme Court held that laws which interfere with the personal liberty of the citizen and with his right to pursue such avocation or calling as he may choose cannot be constitutionally enacted unless the public health, comfort, safety, or welfare demands their enactment, and that it is the duty of the courts to determine whether or not a law impairing the right of a citizen to follow his individual preference in the choice of an occupation comes within any of these exceptions. Then follows a review of the facts from which the court finds the Act of 1897 to be invalid, and the judgment of trial court is therefore reversed. Now, as you can see, all these are positive cases. So, here you go. Let me go right here. Okay, I'm going to start right here if you can see it in the video. There you go. So I'm going to turn it kind of sideways right there. The powers of the city council are enumerated in section 62 of chapter 24. Okay, so what I'm going to do is I'm just going to come all the way down here and go right here. In the city of Chicago versus Collins, a bill was filed by 373 residents, which is an enjoined act, okay? And taxpayers of the city to enjoin, see, there's the word, city from enforcing the ordinance providing that all vehicles used upon the streets of the city, whether they were let for hire or were in private use only, should pay an annual license fee. Failure to obtain a license and or properly tag the vehicle was punishable by fine. Complainants were owners of bicycles used solely in going from place to place and not for hire. They asserted that the city had no power to require a license and for the use of private vehicles upon the streets, nor to impose a tax thereon by way of license. The court held that the right to travel being in the general public everywhere, all persons have a right to pass along the use of the streets and alleys of the city in all their parts. Full length and width thereof, and any method of travel may be adopted by individual members of the public, which is the ordinary method of locomotion, or even an extraordinary method. If it is not, now, go back. What did I just say? Even if it's an extraordinary method. That's your commercial motor vehicle there, Steve Lito. If it is not of itself calculated to prevent a reasonably safe use of the street by others, that the power given to the city to regulate the use of the streets is conferred for the purpose of keeping them in condition for public use and travel, that any usual method of travel along the streets cannot be declared a nuisance, that the regulation as to speed of travel is for the safety of the public. That regulations as to the certain occupations, such as a hackman and others having vehicles for hire, there's your motor vehicles there again, Steve Lido, are occupation license only and are an exercise of the police power that a license implies a privilege, something that cannot be enjoyed without legal authority and cannot be demanded for the exercise of a right, free and open to all, as is the right of the citizen to ride and drive over the streets of the city without charge and without toll, provided he does so in a reasonable manner, and that the authority upon the part of the city to impose a tax and or exact a license must clearly appear and must be strictly construed accordingly. The Supreme Court affirmed the decree of the trial court, which perpetually enjoined the enforcement of the ordinance. Well, well, well. Look at that. And I'm still going to get to... Okay. Here you go. Here's just what it says on the first page. Okay. May 7th, 1903, appellee filed a sworn bill against appellant and others in his own behalf and in behalf of others similarly situated, in which he recites the automobile ordinance enacted by the appellant June 30th, 1902, says he is the owner and operator of an automobile, is experienced in its management, and uses it for his pleasure and in his business as a dealer in such vehicles. That he is not a common carrier, nor does he use his automobile for hire. Common carrier there, Steve Lido, that's motor vehicle. Whoops. That appellant through its agents threatens to arrest him for running his automobile without having first obtained a license in compliance with the ordinance, that he believes such ordinance is unconstitutional and void, in that it is double taxation of personal property, etc., and prays for an injunction against defendants, restraining each of them from arresting or prosecuting appellee or any other person similarly situated. An unsigned and unverified amendment to this bill was filed, alleging that there are in the city of Chicago 1,500 other owners, users, and drivers in automobiles who are affected by such ordinance. On the same day an injunction as prayed was issued, this appeal was perfected from the interlocutory order. That's interesting that he said that. So I'm trying to go through here and find you the actual part of the case that I wanted to show you. But for some reason I'm not finding it. But it is in here. I promise you that. It is in here. The legal maxim. It's in here. But I'm not understanding why I'm not finding it. But, oh, wait a minute. Okay. I hope you guys can see this. I'm sorry. Like I said, I'm just, there it is. Okay, there it is right there. There. Conceding that what is fairly implied is as much granted as what is expressed. The charter of a corporation is the measure of its powers, and the enumeration of those powers implies the exclusion of all others. Thomas V. W.J. Rye Railroad Company 101 U.S. 82. There it goes. So, and that's actually, I don't understand why I had such a hard time trying to find it. Oh, and if you look right up here at the top, it's as a matter of fact, it's mentioned right here at the very top again, which actually takes us to the bottom. In the case of in the city of Cairo versus Bros, right? So if you look right here, when the legislator by the General Importation Act declares that the corporate authority of cities and villages organized and acting under its provisions shall have power to license certain occupations and kinds of business, such declaration must by a familiar canon of construction be construed precisely as if the act in express terms inhibited the licensing of all trades and occupations not contained in the enumeration. Oopsie. That actually says the exact same thing as that which is not mentioned is excluded. So, now, with that said, Dark Angel is going to go ahead and close this out because I done got a little bit weary and got the video all over the place, but the information's out there. So you guys, I highly suggest you guys find this case right here. I highly do, if you can. The sites that you'll see on the internet, which I've spent countless hours looking for this, there's plenty of sites, but they don't cite the parts that they mention of this case, right? Doesn't get the point across. And I noticed that on everything that I was looking at in the cases, that whenever they were citing this case, they wouldn't actually cite the actual point. Now, keep in mind, this case from this, the first page, the second page of the case, there's 7 pages in this case, okay? Okay, 7 pages. Okay, so in this case, in this particular case right here, the Chicago, banker case, of 5 pages. Let me show you. 5 pages right there. From right there, okay, the opinion right there, all the way out to the end, right there, okay, is the opinion of the court. 5 pages of opinion, people. 5 pages of opinion, telling you that a license and registration is not necessary for private automobiles. And it's also letting you know that this law is what to determine that. Dark Angel, man. Deuces.